Thank you, ma'am.
Mr. Horn, can you hear me?
Yes, I can.
Hi, what cases are you here for this morning?
I am. There's quite a few. I'm here for the village.
Okay, there are a few defendants that are here. Would it be helpful to go into a breakout room with them? Judge, is that okay? Is that how you want it?
Well, Mr. Horn, what we're going to do is it's 9:09. My docket starts at 9 o'clock. I start taking defaults at 9:15. If you have defendants here already, Mary Ann's going to make you a co-host. You can go in and out of your breakout room. You can take your tenants in and out of the breakout room. If you find out that they have applied for Sarah between the first hearing and today's hearing, send them back immediately so we can put the Sarah stay in place and get the docket going. The bulk of our cases are Swistak and Levine cases, so I will be ready to go ASAP. So that being the case, Mary Ann, help him get his tenants moved into a waiting room and then the breakout room, and I'll start calling cases for Mr. Visconti and for Mr. Katz.
Okay, yeah, he is co-host now.
Thank you.
Rena. Oh.
Was my instruction clear, Mary Ann?
Yes, Your Honor. I'm trying to get into the breakout room.
You're fine.
The gentleman who just signed on is Sean's Galaxy. What is your name, please?
Excuse me,
What is your name, please?
Sean Washington.
Thank you.
Dana Lawrence. This is 223084 LT. This is GPM Property versus Dana Lawrence. Appearance, please.
Morning, Your Honor. Robert Visconti, P61756 for the plaintiff.
Thank you. Today is the day and time set for the second hearing in this matter. It was scheduled at 9 a.m. The defendant failed to appear at the first hearing on July 20th. For that reason, the court set this matter for in-person for the defendant, Zoom for the plaintiff's attorney. This court has not received any notice from security that the defendant has appeared in the building downstairs for hearing. Scheduled at 9 o'clock is now 9:13 by the court's clock. Defendant having failed to appear. Mr. Visconti, how do you wish to proceed?
Your Honor, at this point, I'd move the court for entry of a default judgment for possession only. Since the last hearing, the defendant has paid his balance down to $110 plus costs, which are $164. So the judgment would reflect a total arrearage of $264, writ to issue in 10 days.
Thank you. Defendant having failed to appear as directed by this court, default judgment shall enter as paid by plaintiff with total rent due, including costs of $264. Plaintiff's office to submit that judgment for entry. Mr. Visconti, you may submit it by email to the civil department. Anything else in this file, sir?
Nothing further in this matter, Your Honor.
This is 223118 LT. This is Belleville Metals versus Dolores Lloyd.
Robert
Dolores
Visconti,
Lloyd. I'm
I'm
sorry. Mm-mm.
Robert Visconti, P61756 for the plaintiff.
Thank you. Today is the day and time set for the second hearing in this matter. First hearing was on July 20th, 2022, at which time both parties did appear. Dolores Lloyd, Kathy Prophet, or anyone else from 9 Capistrano Court, Site C9. This matter having been scheduled at 9 o'clock, it now being 9:14 a.m. by the court's clock. Defendants having failed to appear. Mr. Visconti, how do you wish to proceed?
Your Honor, at this point, I move the court for entry of a default judgment terminating tenancy. A proper notice to quit was provided to the plaintiff, and defendant has not vacated. They did appear at the first hearing. The notice to quit was sent on May 18th, requesting that the defendants vacate by June 20th. So we just ask simply for a termination of tenancy with the writ to issue in 10 days.
Defendants having failed to appear as directed by this court, default judgment shall enter in plaintiff and against defendants with 10 days to move plaintiff's office to submit that judgment for entry. Mr. Visconti, that appears to be your only two files this morning.
Nothing further, Your Honor. Thank you.
Thank you, sir. Have a wonderful day.
You as well.
Thank you. This is 223228 LT. This is GI&I Barrington versus Sierra Adams.
Good morning, Your Honor. Sidney Katz on behalf of the plaintiff.
Sierra Adams. Today is the day and time set for the second hearing in this matter. Defendant failed to appear at the first hearing, which was on July 20th, 2022. Based on the defendant's failure to appear, the court sent notice for the defendant to appear in person this morning at 9 o'clock. This court has not received notice from downstairs that there is anyone here appearing in this matter. Mr. Katz, defendant having failing to appear as directed by this court, how do you wish to proceed, sir?
Your Honor, at this time, this is a termination of tenancy. We're requesting a default judgment and with a writ date of August the 5th, I think it is, 6th. Nope, I'm sorry, August the 8th.
Mr. Katz, are you just making up dates?
No, I forgot it's Wednesday. So it's the 8th. Did I guess right?
I'm gonna write August 8th. That works for me. Defendant having failed to appear, default judgment shall enter. Plan will be entitled to possession. Mr. Katz, please have your office submit that judgment to the court for entry. Anything else, sir?
That's it. I think I'll see you this afternoon. Thank you.
What a joy. Have a good day, sir. This is 222616 LT. This is Wellesley Townhomes Cooperative versus Tracy Payne. Tracy Payne. Today is the day and time set for the second hearing in this matter. The first hearing was on July 6, 2022, at which time both parties appeared. This case was scheduled this morning at 9 a.m. It's now 9:17 a.m. by the court's clock. Neither party has appeared this morning. Based on the failure to appear, this case will be dismissed. And Mr. Levine hasn't sent anyone back yet.
No.
Not Mr. Levine, Mr.
Mr.
Warren. See, that's why we start on time. Because I am in fact ready for people. And this is not gonna work. I can already see this is going too slow.
Do you want me to go in there?
Go in there and do what?
I don't know.
Harv Oliver is back and he's for West Village, Your Honor.
Miss Samples, I love you. Thank you.
I love you.
You always are on time. I don't care what kind of hearing we're having. Holy smokes. I see you log on. I know I need to get in gear and get out here. 3143.
I appreciate that.
I imagine you have other stuff to do on the 27th of the month.
Yes, ma'am.
This is 223143 LT. This is West Village Estates versus Candy Vaughn and Harvey Oliver.
He's not there any longer.
What happened?
He was just there.
I know, I saw him. See, you were teasing me. I got ready, got all excited. We had a case ready. And
Right, and now they've disappeared.
Marianne is always a song and dance, a little something to make the people laugh in this courtroom. Oh, well. Maybe he'll come back. Maybe he thought we were done with him. I don't know. And see, I like this view. This is a lot better with the lakes than with the flowers and the other stuff in the corner.
Oh, yeah, I like that, but I also like the flowers. They did such a great job on that piece of art.
I'm so easily entertained and amused, though. I love living in a state where you just go like this, and yeah, we live right here. Oh, you know what? Taylor has stars downstairs. I'm gonna get a star from Taylor and put it right here where we are.
Oh, okay, I like that.
See, here's the thing, Marianne, it's the end of the month. These community managers, they have other stuff to do. They have to get ready for next month's move-in. They're figuring out who's gonna get a notice this week. No, I don't miss those days. People who promised to move, who aren't moving. What are the concessions that we're giving right now? Who didn't turn in their paperwork? See, Ms. Walker, I'm convinced. I'm talking to somebody. I don't care if there's not a case ready.
We're listening.
The thing is, we're open, but nobody's in the courtroom. So I sit here by myself, waiting for Mr. Horn to be ready, looking for some news if anything is going on.
You know, maybe he doesn't realize that he has to pull them out of the waiting room into his meeting room.
Is he sitting in there by himself?
No, he has an attorney in there with him, but they've been in there for a long time.
Oh,
Should I-
no.
Do you want me to start putting people in his meeting room, a person at a time?
No, I'm sending him a message. Let's go, let's
Okay.
go, let's go. See, I told you, my little situation, my little setup out here is not ideal. So I sat in my at the conference table yesterday during that trial, and I cannot sit there. It does not feel like real court to me.
Yeah.
I like the flag and sitting here, and the Maple Leaf manager is here. Uh-oh. So we have everybody's managers here. I think we should call this their weekly conference since they're here. Get managers updates, what's new in the communities. It's a life cycle for carpet, still 10 years. Has anyone else had a tenant who had a potbelly pig living in the second bathroom? Yeah, I had that case, Ms. Walker. That was me.
We've had people have pigs and chickens and roosters.
Can't make it up.
No.
The piece of carpet that smells so bad, we put it in a Ziploc bag for the judge to smell. Yeah. Because it looked clean, but when you open that bag and you get that magic.
Do you want me to put Miss Samples in his meeting room with him?
If
I
she
would
wants to
guess
go.
so, yes.
You know-
I didn't have to get out if I wasn't gonna be a part of it.
Yeah, I'm gonna put you in his meeting room, and then maybe you can tell him that he needs to pull people out of the waiting room into his meeting room.
100%.
Okay,
I'll
thank you.
handle it. Thank you.
Mary Ann, you're breaking up my morning coffee pledge. I was happy with Miss Samples, but you take her from me, so
I'm sorry.
I'm just giving you a hard time. Oh my goodness. He's sitting in there on the one case and they only owe 1 month in rent. Let me pull this file and see what's the. Mary Ann, you know I like to keep you entertained because your mother pays me extra for that.
And it's well worth, I don't know what she's paying you, but it's well worth it.
I was telling somebody that when I was a young attorney, I started off in 36. And so I would park over at Joe Louis, ride the little shuttle bus over to the office, which I've worked in Penobscot. And then I would walk over to 36 District because walking was better for me than paying to park and moving my car twice. But in any event. And I just got a visit from Jack. I am the happiest person right now. He's not amused by my.
You know, Judge, what I think I should probably do is put all these managers in with the attorney. Would that be helpful?
I will leave it to you because then I can stop telling my stories. Thank you.
No, I love listening to your stories, but managers, do you think that you should be in with the attorney? I can put you in the breakout room with him.
I would like to be.
Okay, I'll put you in there.
Thank you.
You're welcome.
Conway was like, yeah, I've had enough of Judge Martin already. I'm gone.
No.
It's fine. I don't care. Because you might be able to find out quicker if any of these are Sarah cases that we should stay or get an update to help us get this docket moving along. 3117. Oh, Mr. Oliver's back. And then Mary Ann, we have another dismissal.
Okay.
It is 223117 LT Belleville Meadows versus Audrey Smith and James Durbin. Jack just brought the dismissal in. I'm signing it, putting it back in the dismissal pile. Mr. Oliver,
Yes, ma'am.
you disappeared on us. We got nervous.
I can tell. I tried to unmute my phone and somehow it hung up. I actually just called back up there. I think it was your secretary's voicemail they gave me.
Oh,
I'm sorry. Nevertheless, sorry about that. I was trying to make sure I was unmuted.
don't be sorry. I'm glad you showed back up. Thank you for your persistence. 3143. This is 223143 LT West Village Estates versus Candy Van and Oliver. Mr. Oliver, what happened in the breakout room with the attorney?
Oh, I didn't speak to nobody.
Oh,
I kept saying hello and nobody answered me.
it's okay. Sir, between last week's hearing and today, have you filed an application for SARA funding or emergency rental assistance?
I've applied for SEER and MyHalf, both programs.
When did you apply for Sarah, sir?
I applied for Sarah back in March, I believe it was. It's been a while.
You applied for Sarah back in March?
I believe that's when it was, yes. And then I applied for my half in May.
Have you received any information from Sarah that you are not eligible for funding?
No, not to my knowledge, I haven't.
Do you have your Sarah application number, sir?
I do.
Would you give it to me, please?
Yes, ma'am. 500794. And I just called the My Half program at the beginning of the week. They said they was waiting to get a case manager assigned to it.
Ms. Samples, were you aware of the Sarah application from Mr. Oliver?
No, ma'am.
Did you hear his Sarah number?
We wrote it down, yes.
Okay. Mr. Oliver, based on the fact that you applied for emergency rental assistance, this court is required to stay these proceedings, which means not do anything further. The next thing that you will receive from the court is a copy of the notice that this matter has been stayed because of your application for Sarah.
Okay.
If the plaintiff's attorney receives notification that you are not eligible for Sarah, or that your Sarah application has not been funded and payment made to your landlord within 45 days, they may request that the court lift the stay, schedule the matter for additional hearing, and move forward in this matter. Understood?
Yes, ma'am.
Right now, sir, you're free to go. Your file's been noted. Again, the next thing you'll receive is a copy of the notice that says that this matter has been stayed due to your application for rental assistance, okay?
Thank you. I appreciate it, ma'am. Have a good day. Thank you,
Thank you.
Renee. I'll see you soon.
All right, honey,
Okay.
thanks.
Bye-bye.
Thank you. Stay safe. Bye-bye.
I read that. That doesn't matter to me.
I know, and
Okay.
I told him, and I was just writing Marianne, we have all the managers now in that breakout room, but we have no clients in there. And he said he's on 3 different Zooms. Someone called off and he can't do that right now.
Well, here's the problem. Even with Zoom, what I'm gonna have Marianne do is put you all in the breakout rooms and make you co-host and help you be responsible to move people in so we can get these people off of Zoom and back to work or back on with their days. And I'm assuming that you and the others have other stuff to do. So Marianne, if you could do that, please, and I will leave it to Ms. Walker, Ms. Conway, and Ms. Samples to move their particular community's tenants in to speak with them. And if they are Sarah people, bring them right back so we can get them on their way, and Mr. Horan can update himself later.
Thank you.
You're welcome. Thank you, ma'am.
I'm
Yes.
bringing them back into the main room so they know what's going on.
Well, yeah, if you bring everybody back.
No, just the managers.
Oh, thank you.
Yeah, yeah. And Miss Samples, I just made you co-host so you can grab you can move yourself around.
So how do I do that?
Well, Marianne, let's do this. If Marianne brings everybody back, I'll have the one conversation. I see people moving into Ms. Hubbard and Ms. Walker in with Mr. Horan. If you bring the tenants back though, we'll talk to them once so we can figure out how to get people.
Okay, I'm just gonna I'm closing it down and bringing them back and I'll read.
Thank you. Let's try this a different way.
Ooh, she brought him.
Okay, is that everybody? Okay. So I had my secretary close down the breakout rooms because I received information that the only attorney that has cases with me this morning is triple booked, which means that he is in other courtrooms. I will not have people sitting and waiting for him to work his way through the docket. What I will do is if between your first hearing and today's hearing, you have applied for Sarah, I will take your Sarah information on the record, we'll stay your file, and we'll let you go on about your day. If you have not made an application for financial assistance through the Sarah program, we will send you into a breakout room to talk with the manager from your specific community. And if you're able to work out something with them, then you can go on with Mr. Horn and we can figure it out that way. But I'm trying to get people expedited out of here. My docket started a half an hour ago. I don't like you to sit here and wait for us. That being the case, Ms. Ison, since the only answer to the question is yes or no. Since you were last here, have you applied for financial assistance through the SARA program? You
No.
said no? Okay. Sit tight. We're going to get you moved into a breakout room with your community manager.
Thank you.
Your Honor, I apologize.
Why are you apologizing?
I'm apologizing because I'm into court and
Mr. Horan, no, don't apologize. Life happens. I understand. We're going to get people moving, but we're going to help streamline the process. Life
Thank you.
happens. No worries. Sean Blockton, Mr. Blockton, since your last appearance, have you made an application for SARA funding?
Yeah, it's they had ERAP. I've made it. I got a
ERAP,
confirmation.
give me 1 second. It's fine. I just want to pull your file so I can write in it once. This is 223093LT. This is Swan Creek versus Sean Blockton. Mr. Blockton, you were starting to say you applied for ERAP.
Yep, and I have a reference number.
What's your ERAP number, sir?
S19624.
When did you make the application?
2 days ago.
Mr. Blockton, in as much as you've made an application for financial assistance with the past due rent in this matter, this court is required to see these proceedings. The next thing that you will see is a copy of that stay. If 45 days from now, your landlord has not received confirmation that your application has been funded or you've been denied for some reason, they may make a request in writing to this court to lift the stay and schedule the matter for additional hearing. Understood?
Yes.
We're all set. Mr. Blockton, have a good day, sir.
Thank you.
Thank you. Ms. Gibson, were you done speaking with Mr. Horan?
Just about. It did kind of cut into our conversation, but we were just about, I believe we were just about at a something that was amenable for both sides.
Marianne will get you moved back in with Mr. Horan.
Okay.
I think it's better for two. Yep, go ahead.
Thank you.
Mr. Sean Washington,
Yes, ma'am.
give me 1 second to find your file. Sir, since you were last here on July 20th, have you made an application for financial assistance through the SARA program?
Yes, the ERAP.
Give me 1 second to find the file. This is 223147 LT. This is West Village Estates versus Sean Washington. Mr. Washington, what's that ERAP number?
It is S17105.
Mr. Washington, inasmuch as you've made an application for financial assistance, this court is required to stay these proceedings. The stay means that there will be no additional action taken this morning, but what will happen is within the next 45 days, if your landlord has not received either payment in full for the rent that's due and owing, or notice that you're not eligible for financial assistance, they may make a written request to the court to lift the stay and schedule the matter for additional hearings. Understood?
Yes, ma'am.
Okay, we're all set. Mr. Washington, you may log off, sir.
Okay, thank you.
Thank
Have
you.
a good one.
You too. Thank you. Lloyd Evans and is it Jeannie Finley?
Yeah, yes.
Since you appeared on July 20th, have you made an application for financial assistance either through SARA or ERAP?
Yes, the SARA.
Give me 1 second to get your file pulled. This is 223088LT. This is Metro Commons versus Lloyd Evans and Jeannie Finley. State your name for me, please.
Jenny Finley.
Lloyd Evans.
Thank you. So your SARA reference number is?
305-321-research 2022-1.
Inasmuch as you made an application for financial assistance through the SARA program, this court is required to stay these proceedings. That means that nothing else will happen additionally this morning. The next thing that you will receive is a copy of the stay from the court that indicates that if your landlord has not received payment from the SARA program or a notification that you're not eligible for financial assistance within the next 45 days, they may file a written request to lift that stay and schedule this matter for additional hearings. Understood? Anything else this morning?
No, Your Honor.
You're free to go. Thank you so much for your patience today.
And thank you. Have a wonderful day.
You too. Thank you.
You're welcome.
This is Melissa Vaughn and Thomas Vaughn.
Yes, ma'am.
Yes.
You failed to appear at your originally scheduled hearing date last week. Based on your failure to appear, court clerk sent notice to you at your address to appear in person this morning. Is there a reason why you're not here in person?
Because the paper says Zoom.
No, it does not, ma'am. If you look at the top of the page, it says
Plaintiff attorney. I misunderstood that and read it wrong. So that is 100% my fault.
Okay,
And
ma'am. Nope. You're fine. I just asked because when people don't read the paperwork, it makes me nervous about what else isn't being read. Since the original scheduled hearing date, have you made an application for financial assistance through either SARA or ERAP?
no, I have not.
Okay.
I was gathering my resources this past week.
What we're gonna do, Mr. and Ms. Vaughn, we're gonna have you move into a breakout room with Ms. Samples to discuss this case, okay?
Absolutely.
Okay, Marianne will get that taken care of and we'll get your recall when you get done speaking with her. Thank you.
Thank you for your time.
Thank you for your patience. Shaishani Blount,
Yes.
this is 223090 LT. This is Maple Leaf Gardens versus Shaishani Blount and Teddy Booth. Do you know where Teddy Booth is this morning?
He is at work.
I have the same question for you. You were supposed to be here originally on July 20th. No one appeared for the defendants. The court clerk sent you notice to appear in person this morning. Is there a reason why you're not here in person?
I believe I read this wrong.
Ma'am, have you made an application for financial assistance through either SARA or ERAP?
No, I have not.
What I will do is have you go in and speak to a representative from Maple Leaf Gardens, which I saw them here previously. You can discuss the case with them. If you need to go in and speak to Mr. Horn, yep, I see Ms. Conway. We'll get you moved in with Ms. Conway to discuss the matter. If you need to speak to Mr. Horn, we'll do that as well, but we'll get you back out here on the record to speak to me as soon as we can, okay?
Okay, thank you.
Thank you. Ms.
Your Honor.
Your
Honor, this is Jenny Scheid. I'm with Swissack and Levine, a colleague of Mr. Horn's. I'm here to try to help assist because he's being pulled in another courtroom. So,
Ms. Scheid, no, I appreciate you joining him. We can put you in a breakout room and start getting you matched up with tenants, but thank you for backing him up.
yes, no problem. And that's what I'm here to do, is to help.
Thank you.
Judge, do you want me to put her in with the managers in the defendants?
Ms. Scheid, we can do that if you think that'd be beneficial.
Yes, I think so.
Thank you. And, oh, no, Marianne.
Okay, I won't do it.
Well, because I see that Courtney Gibson had been talking to Mr. Horn. He's not there. She's in room number 2 by herself. They have been working on Squires. That's West Village versus Squires. Ms. Scheid, is that something you can help with?
I can.
Okay. Marianne, I'll get you moved in to speak with her.
Thank you.
Thank you. And I saw Sierra Adams appear and now disappear. That case had already been called and defaulted. Okay. Oh, Ms. Adams. Sierra Adams. Sierra Adams. Megan Morrissey.
Yes, good morning.
Good morning. How are you?
I'm all right. Thank you very much for asking. How are you?
I'm good. What are you? I'm looking for a.
I'm for Patrick Morrissey. Patrick Morrissey. I
see
am
it.
his daughter.
Thank
Ella
you.
Manor. Yep.
Give me
I have
one second.
applied for ERAP.
Give me 1 second to pull the file. 3075. 223075 LT. This is BC Belleville Manor versus Patrick Morrissey. Ma'am, where is
Correct.
Patrick Morrissey?
He had a doctor's appointment this morning. My father has declining dementia. We're just trying to get him taken care of.
He's your father, but do you have a legal, are you like?
Yes, I am on the home, the title of the home, and I am under the lease. We've lived here for 22 years. So
You're on the lease as what, ma'am?
his daughter.
On there as an occupant or as another tenant?
As his daughter.
She's an occupant on the lease, Your Honor.
Thank you, because I'm looking at the file and the file is only in his name, ma'am. And you cannot represent him unless you're a licensed attorney in the state of Michigan. But I
Oh, you know
will
what?
ask-
He just walked in the door. Give me 1
No,
second.
ma'am. No.
Oh, okay.
No, we're fine. I need you to work with me for a second.
Okay, I'm sorry.
Since you were here on July 20th, has there been an application for financial assistance through the SARA program?
Yes, ma'am. It was the ERAP.
ERAP, and what's your ERAP number, please?
P19745.
P?
Or maybe it was R.
Are you
Let
looking
me
at?
look 1 second.
Thank you.
Yeah, I'm looking at it. It's right in front of me. I think it was the WayneCounty.com/rental assistance is where I went to file for the application. And then the reference number was, I'm looking at it right now. Sorry, my phone is having a hard time loading. Give me just 1 second. Okay, here it is. Okay, here we go. It is, it's P19745, the reference number.
Ma'am, based on the fact that you applied for financial assistance through a emergency rental assistance program, this court is required to stay these proceedings. The next thing that'll happen is that the court will mail a copy of the stay to you. If your landlord has not received either payment or notification that you're ineligible for funding within 45 days, your landlord may make an application to the court to lift the stay and schedule the matter for additional hearings. Understood.
Yes, ma'am.
Anything else this morning?
No, you have a wonderful day, Your Honor.
You too. Thank you so very much.
Goodbye.
Goodbye. This is a recall of 223090 Maple Leaf versus Blount and Booth. What happened in the breakout room since you're back?
She gave me until the 11th to pay the full amount.
Is that realistic for you?
Yes, yep, I agree to that.
What is the rent that's due and owing?
I believe it's like 2,069.
Like I need the exact number. I thought I saw, is Maple Leaf back? Yep, she's back.
Yep, give me 1 quick second here. There.
So the total owing without the court fees is $1,872.67. With the court fees of $164.50. So that would give a total of $2,037.17.
And Ms. Blount, is your indication that you're able to pay that within 11 days?
Yes, I get a monthly income and my husband gets his check that day and we will be able to have it all.
And ma'am, because you're appearing virtually, this court does not have a signed consent judgment. Are you authorizing your landlord's attorney to sign that consent judgment on your behalf?
Yes.
Ma'am, because they're represented by an attorney and you are not, that judgment will not become final and enforceable for a period of 3 days, okay?
Okay.
They'll send it to the court electronically. I'll sign it and then a copy will be mailed to you.
Okay.
Anything else this morning?
Nope, that'll be it.
Thank you so very much for your patience. You have a wonderful day, okay?
You too, thank you.
Thank you. This is a recall of 223144 LT West Village versus Vaughn and Vaughn. The parties have come back out of the breakout room. What's going on this morning in this matter?
They are going to have their total amount due on July 29th. This Friday, they'll be paying. They owe $765.87 without the court fees. And then when you add the $199 court fees, it comes out to $964.87.
Alyssa and Thomas Vaughn,
Yes.
is it your agreement that $765.87 in rent is doing owing?
I have the total written down as 964.87.
That's not my question.
I'm sorry, I misunderstood your question.
My question is, are you agreeing that $765.87 in rent is doing owing?
Oh,
Yes.
yes, I'm sorry.
That's okay. And $199 in cost.
Yes.
Yes.
Because you are appearing virtually, there's not a signed consent judgment in the file. Are you authorizing your landlord's attorney to sign a consent judgment on your behalf?
Yes.
You understand that because they are represented and you are not, the judgment will not become final and enforceable for 3 days?
Yes.
Ms. Samples indicated that you will pay this amount by July 29th, which is 2 days. By law, there's 10 days to pay. So the judgment that's submitted by the plaintiff's office will indicate 10 days to pay, okay?
Okay.
Don't have to wait that long if you pay it
It
soon.
won't be. I won't be.
Anything else this morning, Mr. and Mrs. Thomas?
As long as you have a wonderful day, I think I'm
That's
okay
it.
with this.
You all have a great day too. Thank you for your patience. This is not typically how I run this courtroom, but I'm just trying to get everybody on so they can get outside and enjoy it before it starts raining.
No.
He's got to go to work.
Oh, have a wonderful day. Thank you.
You as
Thank you
well.
so much.
Bye-bye. Ms. Scheid, you're back with,
I'm done with the Gibson and Squires, if you want to put that one on the record.
I'm ready. I
and
just don't see Ms. Gibson back at,
She's still in the breakout room.
why?
I don't know if we knew we were gonna have this one right away, so, but can-
I'm not rushing you. I'm
okay,
just,
I can move her.
no, I'm just
You guys
enjoying
think-
my day. We've gotten down to a manageable number of people. Ms. Samples has been laughing all morning. Ms. Walker has had the delight that I am in courtroom number 1 over here.
We
Ms.
just want to
Adams.
spend the day with you. That's all.
No, you're not spending the day with me. I try to get this docket done in under an hour, ideally. We'll see what happens. Ms. Adams?
You are, you've been a joy.
Oh, thank you. This is 223228 LT. This is GI&I versus Sierra Adams. Ms. Adams, your case was scheduled at 9 o'clock. It was called at 9:15. You did not join us until 9:34. What's going on?
I was dealing with my kids.
Okay. Ma'am, the case was called, as I indicated, at 9:15 for a 9 o'clock case. Based on your failure to appear, default judgment shall enter in this matter. You need to vacate the premises.
I apologize for that.
I'm sorry?
I apologize for that.
No worries, no apologies necessary, but this court starts calling cases at 15 after the scheduled start time. The attorney for your landlord was here, asked for entry of default, and the court will do that. You have until August 8, 2022 to move. You will get a copy of that default judgment in the mail here shortly. I cannot recall the case as the plaintiff's attorney has left. There was only one case he has scheduled today. Anything else, ma'am?
You said August 8th?
Yes, ma'am.
Okay,
Have a good day.
you too.
Ms. Gibson, this is 223135 LT. This is West Village Estates versus Betty Ann Squires. May I have your appearances, please?
Good morning.
Jenny
Your
Scheid on
Honor.
behalf of the plaintiff, P648886.
Good morning, Your Honor. Courtney Gibson on behalf of the defendant Linda Schmitzer, personal rep for Betty Squires, P75806.
Today is the day and time set for the second hearing in this matter. How are we proceeding this morning?
Your Honor, as Ms. Gibson had indicated somewhat in her appearance, Ms. Squires is deceased and her daughter is the personal rep for her estate. I've spoken with Ms. Gibson and there is an intent to pay the balance that is owed, but there's still some procedural things that need to be finalized in the probate court. So we are seeking a brief adjournment of a few weeks. I did advise Ms. Gibson that the August rent would become due in the meantime. So, but we are hoping to get this situation resolved before the next court date, but we will unfortunately need an adjournment on this one simply because of the probate complication.
Understood. Let's see if we can get a date for you. What does a couple of weeks mean, Ms. Gibson?
I was looking at, I believe we'll have a hearing set within 2 weeks, but just to be certain, as I communicated with counsel, because I'm not, of course, in charge of the court's processing, I think 3 would be best, just to give a little leeway there. So, but within 3 weeks, I believe we should have had our date, and then I'll be able to provide them with documentation. I'll be submitting their bill we'll be submitting them as a creditor for the estate, and so that way we can go forward with them having a little more assurance that they'll be paid. But my client is having difficulty, of course, maintaining not only her the property that she actually occupies along with this one. So that is our intent. But I think 3 weeks, to answer your question more briefly, I think 3 weeks would be good.
I was listening to you. I was looking for a date because we only do landlord tenant. This courtroom only does it twice every 6 weeks. So I'm trying to see if we have some availability on August the 17th. And Marianne, I'm looking, but thank you. August 17th. It doesn't look like we have anything scheduled until, I thought we had exams that afternoon for some reason. Yep. Ooh, we have something starting at 1 o'clock. Is August 17th at 9 a.m. Is that a doable date for plaintiff?
Yes, Your Honor.
Ms. Gibson, is that a good date for you?
It is not. I have a hearing that morning at 9 a.m. In the probate court.
Are they in person or Zoom?
It's Zoom. The one that I have scheduled is scheduled for Zoom.
If we did 10 o'clock, is that, I don't know how long probate's taking. So 10 o'clock or 11 o'clock?
I don't think so, because it's a surcharge hearing, and it may run a little bit longer than a typical hearing. I just don't want to end up, inconveniencing the court in any way.
No, not a matter of inconvenience. If we did it at 8:30, would you be able to come on real quick with somebody from Swiss Tech Levine? Or
I think we could do that. Yeah, before the other one. Yeah, I think we could do that.
Okay.
So
that's the only thing I would have scheduled that morning.
Okay.
So if we put it over to August 17th, 2022 at 8:30 a.m. back on Zoom with me, we'll either be getting an update or you all would have submitted some settlement document before and the court can just enter that.
Okay.
Anything else on behalf of West Village?
No, Your Honor.
Anything else on behalf of Ms. Squires estate?
No, Your Honor.
Thank you for your patience this morning. Ms. Gibson, you have a wonderful day. I'll see you in a few weeks.
Thank you, you too. Thank you, Your
Honor. Wait, is that it?
Your Honor, I think you took care of a lot of the stuff for us, and for which I am eternally grateful. Apparently, we had a perfect storm of scheduling this morning, and I appreciate our managers being very patient with us as well.
What I told Mr. Horn is that life happens, and Ms. Scheid, as somebody who appeared in court with food poisoning, I know how life happens in abundance sometimes. So no worries. I'm looking at our courtroom. I don't see any tenants remaining. So I'm ready to take your defaults right now if you have the numbers.
Okay. I just also want to assure you and the managers, we actually do have an additional new attorney starting on Monday too, that will hopefully help us with these perfect storms. So help is on the way.
Is it a new attorney or just new to your firm?
new to our firm. He actually worked formerly in more of the Bay City Saginaw area. He's going to be working more remotely with us, but like kind of like half remote, half in person. So, but he has some experience in that area, just not in this geographical area, is my understanding.
Okay. So we have your managers been giving you an update on what happened on the dockets?
No, Your Honor, they have
Okay.
not.
Okay, they're not supposed to, but I'm here, so let's try to get this done. We received the dismissals of, do you do it by name or file number?
By name.
Diane Johnson, Maple Leaf Gardens, we received that dismissal. I signed it this morning. Metro Commons versus Crawford and Crawford, received the dismissal this morning and signed it. BC Belleville versus Morrissey. The tenant applied for ERAP. The court is entering a stay. Then we have BC versus Shelby, Ison, and Mark McLean. This is 223081LT. Today is the date and time set for the second hearing in this matter. Both parties were here when the original hearing date of July the 20th, 2022. The case was adjourned to today at 9 o'clock. It's now 9:58 by the court's clock. I don't see either defendant. Ms. Scheid, how are we proceeding this morning?
Well, they did, on Your Honor, I'm so sorry to interrupt. They did appear. I went into a breakout room with Shelby. They're going to be paying, so default judgment would be fine today.
They're not here when I called the case. I thought I saw the Ison name, but they didn't come back out. And if I don't get an update on the record, I can't really take it as anything other than the default. So the rent to retain is
$2,361.62. Court costs of $199.14 for a total owed of $2,560.76.
based on the defendant's failure to remain in session until the case was called, the default judgment shall enter as prayed by plaintiff's attorney, $2,361.62 in rent to retain, $199.14 in court costs, for a total judgment of $2,560.76. Plaintiff's office to submit that judgment for entry.
Will do, Your Honor.
Thank you. Then there's 223086LT. It's Metro Commons versus Gary Brook. Today is the day and time set for the second hearing in this matter. Case was scheduled at 9 o'clock. The defendant had failed to appear at the first hearing, which was July 20th. Defendant has failed to appear this morning. Based on the failure to appear from July 20th, the defendant was sent a notice to appear in person. This courtroom has not received any information from downstairs that there's anyone appearing in this matter. Based on the defendant's failure to appear this morning, ma'am, how would you like to proceed?
We would like to request a default judgment. There is rent to retain of $7,303.20, court costs of $164.57 for a total owed of $7,467.77.
Case scheduled at 9 o'clock, it now being 10 o'clock by the court's clock. Defendant having failed to appear, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession of $7,303.20, $164.57 in court costs, for a total judgment of $7,467.77. Plaintiff's office to submit that judgment for entry. There were Metro Commons versus Lloyd Evans and Jeannie Finley. They've applied for Sarah. There was a consent
Be a stay.
Hmm?
Is that going to be a stay then? Because
It's
it
gonna be a
applied.
state, yes, ma'am. Maple Leaf versus Blount and Booth. There's going to be a consent judgment submitted. Maple Leaf has those terms. They'll send you they have the rental rate and everything else in there. Swan Creek versus Sean Blockton. There was an ERAP application, so there's a stay.
Okay.
Swan Creek versus Edwards, Edwards. There was a dismissal received this morning. The court signed that. Swan Creek versus Jennifer Wolf. The court received a dismissal this morning, signed that. West Village versus Michelle Jones. The court received a dismissal this morning, already signed that. We just took care of the Squires matter. This is 223136 LT. This is West Village Estates versus Jody Templeton. Today is the day and time set for the second hearing on this matter. Ms. Shai, the court makes note of your appearance. The defendant failed to appear at the first hearing. Based on that failure to appear, court staff would have sent notice for the defendant to appear in person this morning. This courtroom has not received notice from security that there's anyone here on this matter. Scheduled for 9 o'clock. It's now 10:03 a.m. by the court's clock. Defendant having failed to appear, ma'am, how do you wish to proceed?
We would request a default judgment against Ms. Templeton. There is rent to retain of $1,338.30, court costs of $164.57, for a total owed of $1,502.87.
Defendant having failed to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession of $1,338.30. There's $164.57 in court costs, for a total judgment of $1,502.87. Plaintiff's office to submit that judgment for entry. This is 223139 LT. This is West Village Estates versus Preston Pearson and Taylor Pearson. Today is the day and time set for second hearing in this matter. The first hearing was on July 20th, 2022, at which time both parties appeared. Matter was scheduled for 9 o'clock this morning. It is now 10:04 a.m. by this court's clock. Defendants having failed to appear, the court makes note of your appearance, ma'am. How do you wish to proceed?
We would request a default judgment against the defendants. There is rent to retain of $923.24, court costs of $199.14, for a total owed of $1,122.38.
Based on the defendant's failure to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendants with rent to retain possession of $923.24. There's $199.14 in court costs, for a total judgment of $1,122.38. Plaintiff's office to submit that judgment for entry. There was West Village versus Handy Van and Harvey Oliver. There has been an application made for Sarah, so there is a Sarah stay in place. West Village versus Melissa Vaughn and Thomas Vaughn. There's a consent judgment. No extra time added on that consent judgment. The defendants were advised of the 3-day rule. West Village versus Sean Washington and Lakeisha Washington. There's been an application for ERAP. This court is entering the Sarah stay in that matter. That's it, Ms. Shai, by my records.
Awesome. You are quick and efficient, Your Honor.
I tried, and Ms. Samples, Ms. Walker, and the other community representatives helped extraordinarily this morning.
And I am very grateful for them. I know they're all wonderful managers and appreciate the assist from them and their understanding, and yours as well, Your Honor. We will try to make sure that this doesn't happen again anytime soon.
Life happens. You thank Mr. Horn for coming on this morning, and you have a wonderful day. Ms. Samples, always a pleasure.
Thank you, Renee.
See you soon. Bye-bye. You're welcome.
Bye.
Thank you, Mary Ann.
Yep. Want me to take us down until 1 o'clock?